All right, let us call this hearing to order. This is the first meeting of the Senate Judiciary Committee Subcommittee on the Courts, and I am very grateful to my friend Senator Kennedy of Louisiana for acting as ranking member on this committee, and look forward to lively proceedings in this committee during this Congress. We have some terrific witnesses, and I'll introduce them briefly before we present our opening statements. We have Lisa Graves, who is the president of the board at the Center for Media and Democracy. Ms. Graves previously served as Deputy Assistant Attorney General at the U.S. Department of Justice's Office of Legal Policy in the Clinton administration, where I also served. As the Deputy Chief of the Article III Judges Division for the U.S. Courts, and as Chief Counsel for Nominations on this Senate Judiciary Committee for Chairman Leahy when he was serving as chair and ranking member. So she is a familiar presence to us in this room. We will then hear from Michael Klarman, who is a professor of law at Harvard Law School, who writes extensively about constitutional law, government, voting, and of course, the Supreme Court, our topic for today. Ben Jealous is a civil rights leader and the president of People for the American Way. He's a visiting scholar at the Annenberg School for Communication at the University of Pennsylvania and a former visiting professor at Princeton University. He was the youngest ever national leader of the NAACP when he served as president and CEO from 2008 until 2013. And he also formerly was managing editor of the oldest black community newspaper in Mississippi. Scott Walter is the president of the Capital Research Center. He was previously executive director and a senior fellow at the Beckett Fund for Religious Liberty. And before that was a special assistant to President George W. Bush on domestic policy. He is a senior editor has been a senior editor at the American Enterprise Institute. And our final witness is Jonathan Adler, the Johann Verhey Memorial Professor of Law and director of the Coleman P. Burke Center for Environmental Law at the Case Western Reserve University School of Law. Professor Adler is a fellow at the Property and Environmental Research Center and has worked at the Competitive Enterprise Institute. He is the author of his 2016 book, Business and the Roberts Court. I'll recognize myself for an opening statement, followed by Senator Kennedy for his opening statement, and then we will proceed with the statements of the witnesses, which I urge them to keep well within the 7-minute limit that we have. I will be policing and enforcing that with the enthusiastic support of all the members of the subcommittee on that point. And then we'll go forward with our questions. As the chair, I will be here through the entire proceeding, so I will reserve my questions until the end to let my colleagues move forward. We are here because our great American republic is enmired in dark money. Huge gouts of anonymized money by covert political influence. The deluge of dark money pours in through donations in the hundreds of thousands, in the millions, even in the tens of millions of dollars. An entire new political infrastructure has been set up in our country to manage the dark money cascade and to hide the donors. It is a multi-$100 million covert operation, and it has unleashed in our republic more than $1 billion spent in political dark money, resulting in what has been called a tsunami of slime. For a long while, this slime machinery was mostly Republican, but in recent years, Democratic dark money has caught up. Now, Republican colleagues have faced massive attacks leveled through Democratic front groups. So perhaps this slime machine can be a bipartisan concern. The focus of the series of hearings we begin today is on the encroachment of the dark money machinery into the judicial branch of government. This first hearing will provide an overview of various avenues of dark money influence. We will dig into each separately in hearings to come. It begins with the selection of judges. A private organization has long sought influence over judicial nominations to be the good housekeeping seal of approval for conservative judges. But when President Trump formalized this gatekeeper role, things turned toxic. First, a private entity obtained controlling influence over judicial nominations to our country's courts. That alone ought to be a problem. Second, the private organization was completely non-transparent in deploying its influence. It was all covert. That's another problem. Third, the private organization accepted massive, contemporaneous, anonymous donations. That's the worst problem of it all. It looks like the gatekeeping function of this private organization was sold or licensed to anonymous bidders, giving huge interests willing to write huge checks a hidden hand of control at the judicial nominations turnstile. Related groups sprang up in coordination with the gatekeeper group, which the Washington Post has reported combined into a $250 million dark money network out to control judicial selection. We don't know who the big donors are behind this clandestine operation or what business they have before the judges they helped into their robes. It appears that the last 3 Supreme Court justices and many Court of Appeals judges were ushered onto the bench through this operation, so it is no small thing. Once a Supreme Court candidate gets through the nominations turnstile, step 2 is to run political campaigns for the nominee's confirmation. For the last 3 nominees, this was done by an organization with massive amounts of anonymous dark money. In each confirmation, 1 or 2 multi-million-dollar anonymous contributions funded the advertising campaigns. There's no reason to rule out that the same donor made all these contributions, meaning someone, from hiding, spent over $50 million to influence the makeup of the Supreme Court. We don't know who they are, and we don't know what business they've had before the court. We do know that the gatekeeper organization and the campaign organization share the same floor of the same building. All the evidence is that this is the same covert operation. In fact, when the leader of the court capture network left his home at the gatekeeper organization to go wage voter suppression, it was the leader of the campaign organization who assumed his leadership role within that network. With justices thus selected and ushered onto the bench, the dark money task, step 3, becomes how to tell them what to do. Private back channels would lose the justices their jobs, so an industry has emerged to hide in plain view the special interest signaling. Dozens of anonymously funded legal organizations have sprung up. Sometimes they go out and find a plaintiff to produce a case, to bring to the court, to solicit the outcome they seek. Sometimes they form up in choral groups of amici curiae to signal the donor's wishes to the court. Again, all of this is covert, funded in secrecy. What evidence we have shows that parties to cases have funded amici in their own case without telling the court, that flotillas of amici funded by the same groups appear without disclosing to the court their affiliation, and that planners and funders of the scheme discuss, quote, orchestration of amicus briefs and private memos. Usually in cases of interest to this operation, the amici flotilla numbers about a dozen. But in a case before the court right now, one of essential interest to the dark money operation, nearly 50 dark money amici have appeared. Nothing says that the funders of this dark money amicus fleet are not also the funders at the nominations turnstile and the funders behind the judicial confirmation political campaigns. There are many questions to answer about who is behind this scheme and how it interconnects and what the reward is for spending such vast sums. But there's no question about one thing. This machinery is operating right now in all 3 of these avenues. We know that. I understand how politically charged this is, but I submit that if the labels were removed, if this were described as a fact pattern in a law school exam, no one would contest that something is wrong here. No private organization should control the turnstile for a country's judicial nominations. Worse, they should not control the turnstile without transparency. They should certainly not be accepting massive donations while controlling the turnstile. And they should not hide the identities of the massive donors buying spots at the turnstile. If we have to have confirmation advertising campaigns, they should not be paid for by anonymous big donors. And no one with business before the court should be engaged in any of this mischief. Courtrooms ought to be open places where you know who is present, not a place where powerful players can come masked behind front groups, hiding both their own identity and their interconnections. The Supreme Court should not be a place that has a special interest controlled fast lane, bringing certain special interest chosen cases before the court at high speed without the trappings of a real case or controversy. The court itself should not tolerate this. But if it won't respond, we must. Senator Kennedy.